everybody, can I have your attention? Can everybody hear me? It's a pretty small room, so I'm going to try not to scream at you. Thank you all so much for coming. My name is Lisa. I'm chair of the New York Law School Moot Court Association, and I just want to welcome everybody. We're very excited to watch our final four competitors argue this challenging and interesting issue today. Before we get started, I want to remind everybody to please turn off their cell phones so that it doesn't interrupt the arguments. And I just want to let everyone know a little bit about how Moot Court runs. It is a student-run organization. So Erin Mackin and Ashley Emerson have run this competition, and two of our other members will be running New York Law School's Wagner competition this spring. So we are very proud of the fact that students do run the New York Law School Moot Court Association. This was an extremely rigorous competition. Ashley and Erin will give all of our guests a little bit more information about how it ran, but all of our competitors worked extremely hard and should be very, very proud of themselves for coming this far, writing their briefs, and arguing in Froessel, which is one of the toughest moot court competitions in the country. So I'm going to introduce our final four members, and then I will turn this over to Jennifer Budoff. So first, we have arguing as petitioner one, Oscar Hagstrom. Oscar, could you stand up? As petitioner two, Chris Arco. As respondent one, Andrew Blancato. And respondent two, Joseph Mancino. I'm now going to let Jennifer Budoff make a few additional announcements, and just so everyone knows, Jenny is the vice chair of the organization, and she has been working hours through this entire competition, calculating scores and making sure that everything upstairs is running smoothly. So let's give Jenny a round of applause for all her work.
I just had a couple other people to thank that really helped out during this entire competition, and without whom it wouldn't be possible to run it so smoothly every year. We wanted to thank Dean Matazar and Dean Buckler. We wanted to especially thank our faculty advisor, Professor Susan Abraham, who really helps us out in all aspects of the competition and is there for really anything that we need of her. In addition to all the professors and faculty who helped to judge our competition, I want to thank the Froessel chairs, specifically Ashley and Erin. Thank you for doing such a wonderful job, as well as the Froessel authors who created a very interesting and challenging fact pattern, Tom and Stephanie, and the editors who really worked kind of day and night up to the last minute editing the fact pattern and making the bench brief for you, Hannah and Sandra, and the alumni and media relations chair, Dawn, who's as well as basically the entire association who really came through for us, judging, timekeeping, judge escorting, and all facets of the competition. And finally, basically the NYLS Moot Court alumni who come back and help us judge and really show their support for us year after year. And now, just to turn it over to the ladies of the competition, Ashley and Erin.
So we're going to ask you to sit through just a few more thank yous here, because there is a lot, obviously, that goes into running a competition. So the first one is to Sanja, who's not here at the moment, but we really couldn't run this competition without her. She's kind of like I guess, the glue to everything. She knows the ins and the outs and the little details that we, wouldn't be able to remember or throw together at the last minute without her. I'd also like to thank Jessica Velez and Sally Harding and Karen Kohler for doing a wonderful job with all of the room reservations. It was wonderful that we got to use the new building this year for a lot of our rounds, so thank you.
We'd also like to thank the Office of Alumni Relations, who's helped us send out the invitations, specifically Jimena Butrego and Tara Regis Tomlinson. We'd like to thank the Office of Public Affairs, the Audio-Visual Department, the security staff who's been an extra help this year with the new building, and also the catering staff, and the Office of Information and Technology, specifically Tyler Seidel and Rosa Milla.
All right, so now we kind of want to give you an idea of where our competitors have been and how they kind of got to this last Final Four step in the competition. The competitors argued through 2 preliminary rounds on Wednesday and Thursday, and then in a double octo final round on Friday morning. So that was kind of just to start it off. Friday afternoon, we made a cut to the top 32 competitors, who then, immediately after being notified that they advanced, had to argue again in the octo finals on Friday afternoon. Friday night, we made phone calls to notify the top 16 what side they'd be arguing on Saturday morning. We had another round Saturday morning, the quarterfinals, then cut it down to the top 8 Saturday afternoon for the semifinals. And again, the competitors had to just turn it around and argue whatever position we told them to. So they've done a really excellent job, and congratulations, guys.
Just really quickly, I'd like to read the bio of Charles W. Froessel, whom this competition is named after. Charles William Froessel, an honored leader of his community, state and profession, received both his Bachelor of Laws and Master of Laws degree from the New York Law School. Froessel rose through the ranks of public service, holding successive offices of Counsel of the Sheriff of Queens County, Special Assistant to the U.S. Attorney General, Justice of City Court of the City of New York, and Justice of the Supreme Court of the State of New York. Froessel then served as an Associate Judge of the New York Court of Appeals, completing a career of honor and distinction in legal and judicial office. Always devoted to legal education and the law, Froessel also served with distinction on Board of Trustees of New York Law School.
So at this point, we would like to turn it over to Dean Matazar and just briefly thank him so much for his continued support of the Moot Court Association and of the Froessel competition. And Dean Matazar will be introducing the final round bench for you.
Thank all of you for your participation this year and making this Froessel a wonderful competition. I've gotten a lot of feedback from students, judges who have been here, and others that the problem is terrific. So congratulations. We'll get our authors in, tell them how great a job they've done. Congratulations to all the advocates. We heard a tremendous amount of positive feedback about the quality and preparation and the sort of dedication of our students toward this enterprise. And of course, a thank you to all of the organizers and members of the Moot Court Board who've done a great job. Professor Abraham, of course, will receive her accolades as a member of this final panel. So my responsibility is to read to you the bios of the judges, which I will do. Our first justice is Honorable Susan Abraham. Susan J. Abraham is an associate professor of applied legal analysis at New York Law School. She teaches evidence, advanced appellate advocacy, and principles of legal analysis, and serves as the Moot Court Association faculty advisor. She's represented indigent criminal defendants in New York and New Jersey, both the trial and appellate level, and has argued many times in the intermediate and highest courts. She's represented clients in disability discrimination, employment, criminal, pension, and other matters. Professor Abraham earned her BA in English from Oberlin College in 1977, her JD from Rutgers Law School in 1983, and received an MFA in creative writing from Warren Wilson College in 1991. Second Justice is the Honorable Christopher Dunn. Christopher Dunn is Associate Legal Director of the New York Civil Liberties Union, the New York affiliate of the American Civil Liberties Union. He also serves as an adjunct professor at New York University Law School, where he teaches the Civil Rights Clinic. In addition, he authors Civil Rights and Civil Liberties column for the New York Law Journal. In more than 20 years at the ACLU, Mr. Dunn has served as lead counsel on cases covering a wide range of issues, including foster care reform, police misconduct, racial discrimination, free speech, and protest rights. He graduated from the University of Pennsylvania Law School in 1985, clerked for John Gibbons on the U.S. Court of Appeals for the Third Circuit, and then he began his career at the ACLU. Third of our justices is the Honorable John G. Kodal. John Kodal is a United States District Judge in the Southern District of New York, appointed by Bill Clinton in 1994. He served as a law clerk to Judge Edward Weinfeld of the Southern District of New York and for Justice Potter Stewart of the United States Supreme Court. Justice Kodal worked in the office of the Watergate Special Prosecutor and then entered private practice in New York, where he was a partner at Debevoise and Plimpton. He earned his undergraduate degree from Georgetown University and his law degree from Harvard University School of Law, where he was editor of the Harvard Law Review. Fourth of our justices is Honorable Jed S. Rakoff. Judge Rakoff is the United States District Court Judge for the Southern District of New York. He also serves as a lecturer in law at Columbia Law School. He served as law clerk to the Honorable Abraham Friedman of the United States Court of Appeals for the Third Circuit, and was Assistant U.S. Attorney for the Southern District of New York. Judge Rakoff has co-authored 5 books, published over 100 articles, and written 600 judicial opinions. He's given over 275 speeches, and he works full-time. He received a law degree from Harvard Law School in 1969, his BA from Swarthmore in 1964, and a master's in philosophy from Oxford in 1966. Final of our justices on the bench is Honorable D. Brooks Smith. Judge Smith serves on the United States Court of Appeals for the Third Circuit. He was nominated to the Third Circuit by President George W. Bush on September 10th of 2001. Previously, he served as Chief Judge at the United States District Court for the Western District of Pennsylvania. He was appointed to that court in 1988 by President Ronald Reagan, and he served there until his elevation to the Third Circuit. As you can see, we've gotten a great panel. I think they'll really put the advocates through their paces. Sorry, advocates, but that's the fun of all this. And I hope everyone has a wonderful time today. Congratulations again to all of you on the Moot Court for a great job.
Thank you again, Dean Madisar. We appreciate your support of the Moot Court Association and the Froessel competition. At this time, I'm going to turn it over to our Froessel co-authors, Tom Boyle and Stephanie Michael. They all deserve a big round of applause for working over the entire summer to create this challenging and interesting fact pattern. So, Tom and Stephanie?
Good afternoon, everybody. My name is Stephanie Michael, and I, along with Thomas Boyle, were the Froessel co-authors for this year. Good afternoon, Dean Madisar, our distinguished guest judges, faculty, and friends. We're just going to give you guys a brief rendition of the facts before we start the competition. Naveed Ali is a 29-year-old resident of the state of Froessel. Born in Egypt, Ali immigrated to Froessel 14 years ago. While he is in the country legally, he is not a U.S. citizen. Ali was registered as a sex offender 10 years ago when he was 19 years old, after he was convicted of statutory rape and providing alcohol to a minor for the purpose of engaging in an illegal sexual act pursuant to Froessel state law. Froessel Criminal Code Section 6-1780 requires that convicted sex offenders who own motor vehicles must register with the Froessel Department of Motor Vehicles and obtain a special chartreuse green license plate. This bright green license plate provides notice of a sex offender's whereabouts. Ali has never contested his status as a sex offender, nor has he ever challenged the requirement of the special license plate. Since his arrest, Ali has worked hard to contribute to his community. Ali was delighted to hear that the Edward Mullen School, a prestigious public high school in the state of Froessel, was implementing a pilot program that offered to teach interested students Arabic. To show his support for the school, Ali purchased a specialty license plate from the DMV. The specialty license plate had the slogan, "It's all about the kids," printed beneath the school's emblem, 2 children holding hands. The plate produced especially for Ali displayed the slogan and the school's emblem on the required chartreuse green license plate. On May 17, 2007, a colorblind child named Tommy O'Flanagan mistakenly thought that Ali's SUV was his mother's SUV because both license plates had the Ed Mullen School emblem on the plate. Ali noticed Tommy standing by his car and took his hand to escort him to a police officer. Tommy's mother saw Ali and recognized him as a sex offender because of the chartreuse green plate. Tommy's mother was enraged. As a result of this incident, an amendment to Froessel Traffic Law, Chapter 92, commonly referred to as Tommy's Law, was passed. The amendment in relevant part reads, "The Department of Motor Vehicles shall prohibit the sale of any specialty license plate to any individual registered as a sex offender in the state of Froessel, where the specialty license plate is produced by or in support of any private or public school located within the state or any youth organization or group located within the state."
Frustrated by the state's intrusion on his freedom of expression, Ali dedicated himself to working towards obtaining a specialty plate for another organization he was involved in, the Arab Acclimation Project, who goes by the abbreviation AAP. The group's mission is to help Arab immigrants of Muslim and other faiths adapt to local communities while still retaining a sense of cultural identity. The AAP wanted a specialty license plate with the group's slogan, "Acclimation through Understanding," written in Arabic. On behalf of the AAP, Ali applied for the specialty plate design pursuant to FTL Chapter 92, Section 2, which sets forth the application requirements needed to receive a specialty license plate in Froessel. Section 2D of the statute reads, in relevant part, that no specialty license plate shall be issued to a group that represents the interest of those who are not U.S. citizens. Ali submitted an application on behalf of the AAP to Commissioner Mary Ann Cloverfield 3 times. Commissioner Cloverfield's third rejection noted that the AAP could not be approved for a specialty plate because it promoted the interest of those who are not U.S. citizens in violation of Section 2D. Ali believed this last rejection was motivated by the Commissioner's bias against both Arabs and Muslims. Ali brought an action in the Federal District Court of Froessel challenging 2 sections of the Froessel traffic law. He challenged Tommy's law on the ground that it violated his First Amendment right to free speech. Additionally, Ali challenged Section 2D of the statute, which prohibits the issuance of specialty license plates to those who are not U.S. citizens, as violating the Equal Protection Clause of the 14th Amendment. The District Court found both sections unconstitutional. On appeal, the State asked the Court of Appeals for the 13th Circuit to review both issues. A majority of the 13th Circuit reversed the order of the District Court as to both sections of the law and ordered that the matter be remanded with instruction to enter judgment for the State. On July 12, 2009, this Court granted Naveed Ali's petition for writ of certiorari to the United States Court of Appeals for the 13th Circuit on the following 2 issues. 1, whether a state law precluding convicted sex offenders from obtaining specialty license plates produced by or in support of local schools or youth organizations infringes on the free speech guarantees of the First Amendment. And 2, whether a state law denying a charitable organization the right to create specialty license plates because the charitable organization is deemed to represent the interests of non-U.S. citizens impermissibly deprives aliens of equal protection of the laws under the 14th Amendment. On a separate note, both Steph and myself want to extend our most heartfelt thanks to Professors Body, Abraham, and Strawson, without whom this fact pattern would not have been nearly as good as it is. I don't think the words thank you can really convey our debt to them, but I guess we'll try. Secondly, both Steph and myself really want to thank the editors, Hannah and Sandra. It was probably no less a Herculean task dealing with either of us all summer, so we really do appreciate all your help. Thank you.
Okay, I think we are ready to begin. So everyone enjoy the arguments. And again, don't forget to congratulate the final 4 competitors who worked very hard to get to the position that they are in. So we will start in just a few moments. Thank you.
Against State of Froessel, respondent.
Please be seated.
Afternoon. As you've heard, this is a matter of Naveed Ali and Arab Acclimation Project versus the State of Froessel. A counsel all ready to proceed. Mr. Hagstrom.
Good afternoon, Chief Justice Smith and Your Honors. Petitioner would like to request 1-minute rebuttal time.
Granted.
Thank you, Your Honor. May it please the Court. My name is Oscar Hagstrom, and I, along with my co-counsel, Chris Arco, represent the petitioner, Naveed Ali, on this appeal. We ask this Court today to reverse the ruling of the 13th Circuit Court of Appeals and hold that Froessel Traffic Law 92 is an unconstitutional infringement on petitioner's rights. My co-counsel, Mr. Arco, will argue that Froessel Traffic Law 92, Section 2D, is an unconstitutional infringement on petitioner's 14th Amendment rights. And I will argue that Froessel Traffic Law Section 6B, otherwise known as Tommy's Law, is an unconstitutional infringement on petitioner's First Amendment rights. Your Honors, this case is ultimately about upholding a fundamental right for free speech. Your Honors, Tommy's Law is a violation of petitioner's First Amendment rights for 3 reasons. These specialty license plates are private speech protected by the First Amendment. They occurred in a designated public forum, and the state has failed to meet the high burden of satisfying a strict scrutiny standard.
Mr. Hagstrom, does your argument depend on a characterization of specialty license plates as private speech? If we find that it's not private speech, but rather a hybrid, or government speech, does your argument fail?
Your Honor, if this court must find government speech, the petitioner's argument will fail. However, if this court were to find hybrid speech, it would be a matter of first impression. There is a case on point which discusses this, which is Planned Parenthood of South Carolina versus Rose. It's a Fourth Circuit opinion, and that court discussed hybrid speech and noted that although the 4 factors that have been used by the circuits, even though 2 of them went in favor of government and 2 of them went in favor of private, there were still fundamental rights that needed to be protected, and there was free speech that the First Amendment needed to protect.
Well, you've referred to 4 factors now, and I presume that you are referring at least in part to the Fourth Circuit's jurisprudence. Court of Appeals judges seem to like multi-factor tests. Is that what you're asking this court to adopt, or is there some other approach that would be preferable?
Your Honor, petitioner's position is that whether or not this court adopts the 4-factor test or not, it would still come to the same conclusion.
Well, but we're a court that is concerned about establishing a rule, not about a conclusion. So what test should we adopt to bind and guide the lower courts?
Petitioner asserts that this court should adapt the 4-factor test simply because it is the most clear and concise means of identifying whether or not...
How is it more clear and concise than what White provides us, which is simply a basic test and seems to have the benefit of simplicity and comparative ease of application, doesn't it, to some 4-factor test?
No, Your Honor. Petitioner asserts that the 4 factors are more easily applied and are more direct because they're able to specify certain matters within the inquiry of who's speaking. And in order to identify those factors, it's important to discuss them. The factors are the central purpose, the editorial control, the literal speaker, and the ultimate responsibility.
Why isn't it a more reasonable test to just ask how would a reasonable observer view the speech as to whether it is speech by the private individual or whether it's speech by the government?
It would be not a clear enough standard set forth. And that consideration is actually part of the 4-factor test. That would go towards the literal speaker and the ultimate responsibility, in which those 2 factors do consider.
The 4-factor test is not binding, is it?
No, Your Honor.
It's just factors that judges are obliged to look at among all the relevant factors to make sure they at least cover that ground. Is that right?
Yes, Your Honor.
And even applying the 4-factor test, it's not clear what the answers are to each factor. It still leaves a lot of room. For example, determining who the literal speaker is. A court could look at a license plate and say the literal speaker is the government, and somebody else could say it's the individual. I mean, it's not easily determinative. Those factors don't necessarily determine the outcome, do they?
Well, no, Your Honor. The factors themselves don't. But like any other factors, you have to look at the relevant facts and apply them. The petitioner's position is that if we were applying the facts of this case, the literal speaker would be the individual because they go out of their way to obtain these license plates. They pay money for them. They choose to affix them to their personal property, being their vehicles.
You're not challenging the portion of the statute that requires sex offenders to have chartreuse license plates. Is that right?
Except on stylistic grounds, of course.
No, Your Honor. That is not an issue today.
But if the statute requires sex offenders to have chartreuse license plates, isn't that a pretty good indication that this is really, that the license plates are really government speech because no individual person would reasonably get a license plate which is chartreuse and identifies a sex offender any more than they would get a license plate with a scarlet A?
No, Your Honor, although that is an important distinction in these facts as opposed to previous cases, as far as applied to government speech, this court itself in Johans versus the Livestock Marketing Association 2005 set forth the principle that when looking to government speech, it's important who sets the overall message. And in this case here, it was a private organization who set the overall message. The government didn't set it from the beginning, and the government is not expressing its own policy through a PTA message.
But Counselor, I'm sorry.
No, how can we distinguish between the fact that the government requires chartreuse license plates and your argument that the rest of what appears on the license plate is then private speech rather than governmental speech?
Well, if we're looking to what a reasonable person would think, there are several sex offenders that have a plain chartreuse license plates within the community. So if there are other members of the community that are sex offenders that have these chartreuse license plates with specialty emblems on them, one could come to the logical conclusion that it is not the government mandating it, and therefore the private individual who has taken the greater lengths to pursue and obtain that license plate and voice their speech.
Mr. Hagstrom, doesn't our decision in Woolley help you in terms of determining if this is government or private speech? What's your view about how that case affects this case?
Yes, Your Honor. Woolley does help us here. The facts of Woolley were the government in New Hampshire, we were compelling citizens to use their motto, live free or die, on their license plates, and the court in Woolley found that there was First Amendment protection needed in that case. And similarly here, there's a need for First Amendment protection. Even further from that case, here we're dealing with the message that private individuals chose to adapt. And it has even more implications of private speech in that regard.
Isn't there a distinction, though? Because in Woolley, there was a government-issued license plate, and the individual spoke or sent a message by covering part of the message on the license plate. So there was no doubt that that was not part of the government message. Here, it's a government-approved license plate. The government maintains editorial control over the messages on all the license plates. It's officially produced or printed, and there's no way of knowing that it's an individual message. Isn't that an important distinction?
Your Honor, that's a distinction. However, the message started with the private entity, whereas in Woolley, the government actually crafted the message, which is similar to the Johans case decided by this court recently, saying that that is an important factor to determining government speech. Here, it's a private individual's message that they've adapted, which was crafted by a private organization.
Why do we have to get trapped in this either-or situation? What about the suggestion of that obscure circuit, whatever it was? Oh, yes, the Fourth Circuit. That consistent with our precedents, there can still be a hybrid.
Yes, Your Honor, there could be. And if this court must find that it is a hybrid, the petitioner's position is that there should still be protection of First Amendment rights in that case, because there are important fundamental rights. A person is still exerting their speech, and if they were not protected at all, then it would violate the Constitution of these United States.
If it's hybrid speech, what's the appropriate test for our standard of review? Is it rational basis review, strict scrutiny, somewhere in between?
Well, since there are still private speech implications that need protection, it would still be subject to a strict scrutiny standard, assuming that it was a designated public forum, which is the petitioner's position here today. The reason why the petitioner asserts a designated public forum is because this court had set forth a rule in Cornelius versus NAACP Legal Defense and Education Fund in 1985, which states that if the government intentionally opens a non-traditional forum for public discourse, it's a designated public forum. That's exactly what's happened here. The government intentionally opened this forum, didn't need the forum, and already had license plates to identify vehicles. The government took an extra measure to allow people to voice their expressions on these license plates that are optional and pay more for that matter, which is public discourse.
But in that, if that's your argument, then you are saying that Woolley doesn't really apply, because that wasn't part of the designated public forum where the government opened a forum for people to speak. That was live free or die was the state's message. So then all of the reasoning underlying Woolley wouldn't really apply to this argument. Is that correct?
No, Your Honor. Woolley still applies in the context of discerning whether or not it's private speech. Woolley can be distinguished in the sense of a forum analysis. However, Woolley is still important to determine that the government is not speaking in this license plate context, and that's the rule of law that the petitioner asserts applies here today.
If we eventually decided that the proper standard of review is rational basis, would you agree that we end up upholding the statute?
No, Your Honor. The reason being is under a rational basis, or it must be a distinction that's reasonably made for the forum's purpose. In this case, the forum's purpose here is soliciting funds for charitable organizations within the community, and here, what the state did was target.
But this particular branch of the statute is really for the protection of children, isn't it?
Yes, Your Honor. The compelling state interest that the state asserts is to protect children. Petitioner concedes that that is a compelling interest. However, it's not reasonably related because the state has put forth no reasoning or no logical basis why these license plates would protect children.
Well, is it the state's burden under the rational basis test to put forward a reason or a record, or isn't it that if they, or in fact we, can think of a conceivable reason that is sufficient? And isn't the obvious conceivable reason that, as Judge Kodal said, it's designed to protect children? These plates could attract children. Prohibiting sex offenders from getting these plates will protect children.
Yes, Your Honor. It's not the state's burden to put forth official evidence to show that these license plates would in fact help children. However, it's the petitioner's position that there's no sound logic because there's nothing saying that a youth organization would be affected simply by support and money donated from a class of persons who have a criminal conviction as a sex offense.
Well, what about the argument that the state has made that symbols of youth organizations and schools might attract children, as it did attract Tommy in this case because it was familiar to him, and the other argument that a plain chartreuse plate, just the clarity of it, makes it easier to identify, and so that's a safety concern as well?
Yeah, yes, Your Honor. Again, the petitioner's position is that the reasonable basis is not directly related to the forum, but even if this court found that, the applicable standard here is still strict scrutiny because we're dealing with the designated public forum. And under that standard, the state would certainly lose because they have not narrowly tailored this law to achieve the compelling state interest that they assert, which is protecting children. What the state has not done is they have not distinguished this law in order to protect children as opposed to schools in general. The word school is very broad. It could apply to universities, graduate schools, even law schools, Your Honors, which does not narrowly tailor the law in order to protect the youth. Now, that by itself is a failure by the state to satisfy the burden of strict scrutiny. And for that reason, this law must not stand. Thank you, Your Honors.
I agree, by the way, that protecting children from lawyers is a compelling state interest.
Mr. Arco.
Good afternoon, Chief Justice Smith, Your Honors. May it please the Court. My name is Christopher Arco, and I represent the petitioner Naveed Ali on this appeal. We ask that this Court overturn the 13th Circuit Court of Appeals holding that Froessel Traffic Law Section 2D does not violate petitioner's 14th Amendment rights. Your Honors, this case is about protecting the constitutional rights of aliens who, because they cannot vote, have no recourse against unconstitutional laws except to pray for relief from these courts.
Now, where do you get anything from the plain text of the statute that has anything to do with aliens?
Your Honor, FTL Section 2D specifically says that it targets the interests of those who are not U.S. citizens, and according to United States Code, anyone who is not a U.S. citizen is an alien. Your Honors,
That's not what the statute says in its entirety, is it?
Your Honor, in its the statute in its entirety is specifically related to the process for applying for a specialty license plate. But the relevant section is Section 2D. That is what the petitioner is challenging.
Well, I'm talking about subsection D because it speaks to a group that represents the interests of those who are not U.S. citizens, does it not?
Yes, Your Honor, and it specifically targets non-citizens by talking about groups that represent their interests. And as such, the statute creates a classification based on alienage, which on its face, according to this Court's holdings in the cases Graham v. Richardson in 1971 and Nyquist v. Marclay in 1977, because it targets aliens, it is subject to strict scrutiny review.
Well, Mr. Arco, let me ask you, to pick up on Judge Smith's question. The cases you're talking about are cases that expressly talk about aliens. This is a statute that does not expressly talk about aliens, but you argue has a direct impact on aliens or is targeted at aliens. What cases can you point to where this Court has construed a statute that does not speak about aliens but is targeted at aliens as being alien discrimination for purposes of the Equal Protection Clause?
Your Honor, the petitioner argues that by looking at the statute in its entirety, it becomes discriminatory in purpose and effect, and that would trigger strict scrutiny under this Court's holding in the case Washington v. Davis from 1976. The statute is discriminatory in purpose because if this Court will look at the statute in its entirety and not simply take Section 2D out of context, Section 2C, Part 2 says the remainder of the funds must be used for the group's charitable purposes within the community. The state's purported interest in passing Section 2D was to further elucidate its concerns to keep the charitable funds within the community.
Do you contend that the statute discriminates against the petitioner because he is a non-citizen?
Your Honor, the petitioner argues that the statute discriminates against the petitioner's 14th Amendment rights because his application on behalf of a group that was deemed to represent the interests of non-U.S. citizens was denied 3 times by the state of Froessel.
Okay, but
does it make any difference that the Arab Acclimation Project is not itself a party to this lawsuit?
Your Honor, the standing of Petitioner Naveed Ali as having standing to bring the suit is not an issue on the appeal. Your Honor, I would like to jump back to how...
True, but just in thinking about why the statute allegedly violates the Equal Protection Clause because it discriminates against aliens, does it make any difference that the group that represents non-citizens is not a party?
Your Honor, it is not relevant to this appeal. Petitioner argues respectfully that that would not be relevant to this appeal because the petitioner did submit an application on behalf of a group that was deemed to represent the interests of non-U.S. citizens.
Well, with respect to the application and the letters that you referred to earlier, I'm a little confused on this point. Is this a facial challenge, or is this a challenge as applied to the application made by your client?
Your Honor, the petitioner argues that this is a facial challenge, and even if this Court finds that the statute is not facially discriminatory, petitioner is prepared to demonstrate that it is discriminatory in both purpose and effect.
Okay, but I just want to make sure that when you say it's a facial challenge, so what is your position on whether or not the letters and the actions of the Commissioner have any bearing on a facial challenge?
Your Honor, the letters of the Commissioner demonstrate that this law is discriminatory in effect. Because when the Commissioner denied Ali's application, and when she denied it because she deemed that the Arab Acclimation Project represented the interests of non-U.S. citizens, she was speaking as a representative and an agent of the state of Froessel. So when she denies the application to the petitioner's application, she is speaking on behalf of the state itself. And even though she may not have passed the law herself, her actions demonstrate that this law is discriminatory and has been used to promote a discriminatory effect.
But doesn't that go beyond a facial challenge to the statute and argue that it's being unconstitutionally applied because the state is applying it with the purpose and effect of discriminating against aliens?
Your Honor, petitioner argues that it is discriminatory in purpose and effect to show that this statute should be subject to strict scrutiny review. And if this Court is to find that the statute is facially targets a suspect class under Nyquist and Graham, then this Court should apply strict scrutiny review. And if this Court does not find that it is facially discriminatory, petitioner has demonstrated that it is discriminatory in effect and it is discriminatory in purpose because the legislature took the affirmative step of adding Froessel Traffic Law Section 2D to specifically target a group that represents the interests of non-U.S. citizens.
What do you take to be the meaning of the phrase interests of those who are not U.S. citizens? What kind of interests are we talking about?
Your Honors would have to pose that question to Petitioner Cloverfield because she is given...
No, I'm going to, don't worry.
She is given broad and arbitrary discretion to determine without any guidance what it means to represent the interests of non-U.S. citizens, which...
So is part of your challenge, your facial challenge, is partly that this is so undefined and so broad that it has a propensity to be usable in a discriminatory way, even if, in fact, we don't reach whether it has, in this case, been used in a discriminatory way.
Your Honor, Petitioner argues that the Commission... I'm sorry, Your Honor, could you please repeat the question?
Yeah, no one understands. My wife doesn't understand me either. If interests of those who are not U.S. citizens is undefinable, is that a basis in itself for a facial challenge?
Your Honor, it may be. However, Petitioner argues that the broad language demonstrates that the statute fails under one of the two prongs of a strict scrutiny analysis. And that is highlighted by holdings in both the Fifth and Sixth Circuits. The Fifth Circuit case, Leclerc v. Webb from 2005, and a Sixth Circuit case, the League of United Latin American Citizens v. Bradison from 2007. Each of those cases examined statutes which targeted aliens. However, the court found in each case that the statute was not overly broad and was narrowly tailored because it specifically targeted non-permanent resident aliens.
Mr. Arco, if I can just interrupt for a minute because I'm back to the original question. I'm not quite sure I understand your answer. If we interpreted the language of this statute to mean that a license plate couldn't be issued that benefited people, French citizens living in France and Italian citizens living in Italy, would that violate the 14th Amendment? Or is your argument, because the term is conceitedly vague, it's broad, and I understand your argument to be that it's facially discriminatory because it could be interpreted to target people that are protected by the 14th Amendment, but that it's not clear. But if that's not your argument, correct me. If we interpreted the statute to mean that we wouldn't allow license plates that benefited Italians living in Italy, would that violate the 14th Amendment?
Your Honor, it may violate the 14th Amendment. However, it would certainly be a petition that would probably be denied by Commissioner Cloverfield under Section 2D. And I'm sorry, Your Honor, could you please repeat the question? I'm not sure I fully understand.
Is part of the problem with the language of the statute and what makes it unconstitutionally vague the fact that it's not clear what it means and it can be applied in all different ways? Is that your argument? Is that part of the problem?
Yes, Your Honor. And again, the petitioner argues that the problem with the vague wording of the statute demonstrates that it is not narrowly tailored. And by applying a strict scrutiny standard of review, a statute cannot pass strict scrutiny if it is not narrowly tailored. So by not being a narrowly tailored statute, as the statutes in LULAC and Leclerc were, the statute fails to pass the first prong of a strict scrutiny review. Your Honors, the statute does not address a compelling state interest because any state interest that the commissioner argued that one of the state interests in her letters.
Let me go. You argue from what the commissioner said in the commissioner's letters, and you go from there to what the purpose and effect of the statute is. But there are no findings, no factual findings, are there, with respect to the purpose and effect of this particular statute?
Your Honor, the petitioner argues that the purpose of this statute is clear by looking at the statute in its entirety, that being Froessel Traffic Law Section 2 in its entirety.
But if that's true, if it's clear just by looking at the statute, why are we discussing what the commissioner said in the letters that the commissioner wrote?
Your Honor, the letters that the commissioner wrote demonstrate that under a standard of review, the statute cannot pass. And
the question was not about the letters. The question was, why are you conflating the issue of purpose and effect, why are you talking about the letters from the commissioner if what you were attacking initially is the face of the statute itself? What's your focus here?
Your Honor, the petitioner argues that the statute is discriminatory on its face, but in the alternative, if this court does not find that FTL 2D is discriminatory on its face, the petitioner argues that the statute is discriminatory in purpose and effect. And the petitioner highlights the letters from Commissioner Cloverfield to demonstrate that the law is discriminatory in purpose and effect. Specifically effect because Commissioner Cloverfield's letters demonstrate how this law has been applied. And petitioner argues that that triggers a strict scrutiny standard of review under Washington versus Davis. Because even if this court does not find the statute is discriminatory on its face, it is discriminatory in purpose and effect. Your Honor, petitioner would also like to make an important policy argument relating why this court should apply strict scrutiny standard of review rather than an intermediate standard of review. Your Honors, aliens by their nature do not have the right to vote. However, petitioner Naveed Ali has lived in the state of Froessel for 14 years. During that period of time, he's paid taxes, he graduated from university. Many aliens that are similarly situated are even required to register for the draft. The petitioner, over the course of his 14 years in the state of Froessel, has significantly contributed to its economic growth. However, because the petitioner is an alien, like all aliens, he does not have the right to vote.
Well, Mr. Arco, let me just ask you one question. Would you agree that this statute could, as well as applying to his group, apply to a group that is comprised entirely of U.S. citizens who are, let's say, trying to advance the interests of Italians here in the United States? Would the statute apply to them?
No, Your Honor, it would not, because, again, the Commissioner Cloverfield would have the ultimate discretion to determine whether or not that would be the case.
No, but I'm asking you in terms of the statute. We're looking at the statute. To a group that represents the interests of those who are not U.S. citizens. So let's say I and 25 other of my American citizen friends form a group to advance the interest of Italians. Am I excluded from participating in this program?
It would depend on whether or not the Commissioner determines that those interests could be kept within the community or if it would divert funds outside of the community itself.
Well, do you agree that number 2, the remainder of the funds must be used for charitable work in the community? Is your argument that that also is violative of the Equal Protection Clause, or are you okay with that section?
No, Your Honor. Petitioner does not argue that 2C Part 2 violates the Equal Protection Clause, but in context, in complete context, when looking at Froessel Traffic Law Section 2D in context of 2C Part 2, because 2D is an unnecessary extension of 2C, and because 2C already addresses the state's purported economic interest, by passing 2D, the legislature was specifically targeting groups that represent the interests of non-U.S. citizens in making the determination that they cannot keep charitable funds within the community.
Do you think that the state's argument that there is a valid economic reason for the statute to keep funds within the community is a rational economic reason for this particular provision?
Your Honor, I see that my time is up.
You may answer the question.
I'm sorry, Your Honor, could you please repeat the question?
Sure. Do you think that the state's asserted reason of attempting to keep funds, the 50% of the funds that the organization has within the community, is a rational economic basis for this particular provision?
No, Your Honor, because it would be irrational to assume that non-citizens cannot keep charitable funds within the community. Thank you, Your Honors.
Thank you. Mr. Blancato.
Good afternoon, Chief Justice, Your Honors. My name is Andrew Blancato, and I represent Respondent in the state of Froessel, along with my co-counsel, Joseph Mancino, on this appeal. Respondent asked this court to affirm the decision of the Court of Appeals for the 13th Circuit and uphold that the Froessel Traffic Law, Chapter 92, Section 6B, as well as Froessel Traffic Law, Chapter 92, 2D, are both lawful regulations. My co-counsel will argue that Section 2D does not violate the 14th Amendment, and I will be arguing that Section 6B, commonly known as Tommy's Law, is a lawful regulation of convicted sex offenders for the following 3 reasons. First, specialty license plates are more in accord with government speech than they are with private speech. Second, Were this court to conclude that these specialty license plates do indicate private speech, the statute should still stand as a viewpoint-neutral restriction in a non-public forum. Lastly, Tommy's Law should be held as a permissible because it stands as a restriction which is reasonable in light of the forum's purpose.
What do you think is the proper test to determine whether speech is government speech or private speech for purposes of a license plate?
Well, Your Honor, I think this court should look to its recent decision handed down in Pleasant Grove, Utah versus Summit. It's a very similar factual pattern to the case at bar. We have the interrelationship of private expression with public property. Specifically, in that case, we were dealing with privately donated monuments on public parks. Now, certainly, this court held that government speech was implicated through these privately donated monuments. If this court can rule...
But what do you suggest the test is for us to apply to determine whether speech is government speech or private speech? If we had to express the test in 2 sentences or so, how would we advise the lower courts to decide whether something is private or governmental speech?
Not that we ever speak in 2 sentences or so.
Well,
or not that we ever advise the lower courts. But
I believe this court should look at a number of factors, specifically who bears the ultimate responsibility.
So you're advocating a multi-factor test?
Believe it or not, Your Honor, I am. This court has loosely adapted the SCB test that was mentioned by petitioner in its ruling of Johans versus
the beef case.
The beef case, excuse me, Your Honor. And in doing so, this court decided that government speech was implicated in that message campaign. It looked at such things as who bears the ultimate responsibility, who has editorial control.
Don't you think the test that has been used by the Seventh Circuit in White that simply asks what would a reasonable person conclude as to whether the speaker was a government or a private party is easier of application?
Your Honor,
doesn't it do the same heavy lifting that the 4-part test you advocate?
Your Honor, I don't believe so. I don't believe it is in depth, and for a case as explicit and multi-pronged as this one, I don't believe that is a sufficient test. However, if we were to ask that, I believe that the facts of this case show that the citizens of Froessel have recognized that specialty license plates in general, are certainly related to government functions and government speech. If we look at Linda O'Flanagan, the mother of the little boy this law was named after, she, after all, the incidents that happened with her child, wrote her state assemblyman to get something changed with these state license plates.
That doesn't indicate that what was on his license plate was government speech. That only indicates that the state controls what people are allowed to, what messages they're allowed to put on their license plates, which sort of points to why the 4-factor test doesn't really help us all that much, because there's always some editorial control. Most instances, or many instances of speech, are hybrids anyway. So why are we wasting our time, as Justice Souter said in his concurrence, in summum, with this jurisprudence of labels? Is that really helpful? Isn't there a more helpful way to actually analyze this? Why are we wasting so much time deciding whether it's more like government or more like private speech when many of these things are a combination?
Well, Your Honor, I believe the repercussions of deciding whether it's government or private speech are too heavy to just determine if it's a hybrid speech. If it's a government speech indicated, the protections of the First Amendment do not apply.
Well, what if we decide it's a hybrid form of speech? Then what's your argument to us?
If you decide that this is a form of hybrid speech, this restriction can still be permissible if it is viewpoint neutral and in a non-public forum. Now, it is the contention of respondent that this indeed is viewpoint neutral because the viewpoint of sex offenders is not simply just being cut off. They can still support local youth organizations and schools in several other meetings.
Do you think it is relevant at all that the state requires sex offenders to have chartreuse license plates in making a determination as to whether this is government speech or private speech?
Absolutely, Your Honor. I believe the fact that this is chartreuse green license plates is very important for not only a form analysis, but in determining whether this is government speech or private speech.
Why isn't it possible to simply divide up the issue of the color of the license plate and the additional message that's on the license plate?
Well, the fact of the matter is, for Ali to have any license plate, whether it be traditional or whether it be specialty, he must get a green chartreuse license plate because he is a sex offender. Now, because of this...
But if he has a green license plate that says, "Go Giants, go Yankees," no one would think that that's government speech saying, "Go Giants, go Yankees."
Certainly not, Your Honor. However, once they see that green chartreuse...
I'm from Western Pennsylvania, where we cheer for the Steelers. It would just be considered bad judgment there.
I would agree, Your Honor. However...
Well, you just lost my vote.
Your Honor, the fact of the matter is the speech isn't the only thing being presented here. Although these logos or emblems may seed certain private speech or private expression, the fact of the matter is this is a green license plate which the residents and citizens of the state of Froessel have understood serves the purpose of putting them on notice that the driver is a sex offender.
There's no question that the green part of the license plate is government speech. But the other part, where the sex offender might choose to add some message that's part of a specialty license plate, that's the question.
Yes, Your Honor.
Why would any reasonable person looking at that think that the message part was state speech?
I'm sorry, could you rephrase your question?
Why taking the distinction that was just made? Why, if you're driving behind this car, you see the green license, you know it's a sex offender, but then you see some message on it. Why in the world would you think that that message had anything to do with the state?
Your Honor, it's not necessarily that the driver of the car, passenger, or other vehicles on the road are under the impression that it's for the kids is a government speech, but we have to weigh the factors of what implicates government speech or private speech. The fact of the matter is this is government property. This is a government license plate. The color green of these chartreuse license plates.
I know all that, but that only follows if we adopt your multi-part test. But if we're adopting the more general test of, under all the circumstances, what would a reasonable person think, why in the world would a reasonable person think this is state speech?
Well, Your Honor, I don't believe a reasonable person might necessarily look at this license plate and see it. I think we have to look beyond just the speech implicated on this license plate.
Why in the world would we conclude that this is government speech even if we adopt your four-part test, or rather the Fourth Circuit's four-part test, which you are urging upon us? Walk me through, if you will, those four factors and explain to me why they yield the conclusion that this is government speech.
Well, Your Honor, the first tenet of that test is the central purpose of the program in which the speech in question occurs. Now, the program is, indeed, the specialty license plate program is to promote charitable interests. But the program of the chartreuse green license plate is to put the public on notice of sex offenders. So certainly, I believe that weighs in favor of government speech.
Well, but just a moment. I think you're attempting to use the chartreuse aspect of this to bootstrap the issue. You said right from the beginning there, the central purpose of the program is to allow these private entities to engage in speech, essentially. So if that's the central purpose of the specialty plate program, let's set aside the chartreuse. Doesn't that point almost irrevocably right there to this being private speech?
Your Honor, the two cannot be differentiated in this circumstance because Ali cannot get a license plate that is not green and chartreuse.
Would your position be different if you didn't have a chartreuse part of this program and we were just having a dispute about specialty plates?
Perhaps, Your Honor. But this law has not been contested. The fact that Ali is a sex offender has not been contested.
No, but you're trying to rely on that part of the program to defend the challenge that is being brought to the part that is challenged, namely the specialty plates.
If I may explain myself, Your Honor, even if this court were to view this as private speech, this court has ruled that, as I said before, a viewpoint-neutral restriction in a non-public forum is permissible if it's reasonably related to the forum's purpose. Now, this court held in Cornelius versus NAACP, that it is the, relevant purpose that is at stake here. And the relevant purpose here, because Ali cannot get a license plate that is not chartreuse green, the purpose that is relevant purpose is the chartreuse green license plate and not the specialty license plate program. Now, within
I'm sorry, could you repeat that purpose? I couldn't quite follow. The purpose is what?
The relevant purpose here is not the specialty license plate program. The relevant purpose here is the color of the chartreuse green license plate.
Well, there's no question that everyone agrees that part is government speech. So the only thing at issue here is the other message. And so I think that's what we really need to focus on and not keep coming back to the color. What's the purpose of the law that prevents sex offenders, registered sex offenders, from adding a message to the chartreuse color?
Well, you have to balance out the benefits of this message and the reasons this state has put the restriction of a chartreuse green license plate. The fact of the matter is, we ask if whether the challenged law, in this case Tommy's law, is reasonably related to the forum's purpose, which we've decided is the green chartreuse license plate. Certainly it is reasonably related. It is not only reasonably related, it is the means by which this state achieves the purpose of protecting its local citizens, its children, and putting them on notice of sex offenders.
So if that's the purpose, don't the facts of this specific case actually contradict that? Because Tommy's mother actually could easily identify that this was a sex offender by the chartreuse color, even though there was a message on the plate. So there we have factual evidence, anecdotal, but factual evidence that, in fact, it doesn't at all confuse people. People are still quite aware that sex offenders are sex offenders by the background color, despite the message.
Well, Your Honor, she may be able to identify and differentiate the two, but it is not her we are trying to protect with this law. It is the children of this state that we are trying to protect.
Do they know that chartreuse means someone's a registered sex offender? Or have they been educated about that in school?
Maybe not, Your Honor, but within these green license plates, it certainly would take away from their point, the reason they are there, to add a slogan that may attract these children. Conflicting these two would certainly destroy the purpose of this chartreuse green forum.
Could I assume for a moment that we decided that this was private speech, the issue of organization, affiliation on the license plate. What do you say our standard of review should be with respect to the state's purpose to determine whether this is a state purpose that should be honored?
Well, Your Honor, because this is a case of first impression, I believe that the standard of review should not be strict scrutiny, but should be weighing whether the challenged law is reasonably related to the forum's purpose. As I've said before, Tommy's law is a restriction on sex offenders, and the forum's purpose is to put the public on notice and to put children on notice that these sex offenders have committed crimes, and thus Tommy's law acts as an avenue for which this for which the state achieves this forum's purpose. And the fact of the matter is, if we were to overturn this, if we were to decide that this law does not protect these children for some reason, it would be if we were to decide that this curtails the freedoms of Ali, it would destroy the purpose of this forum. And we cannot take this risk when the children of Froessel are what is at risk here. This is, after all, a restriction on people who have committed sexually related crimes.
But we still have the protection in the chartreuse plate. What's the added danger to children by allowing people, is it by allowing people to add some speech to their chartreuse plate when we know from the record they're still identifiable? And in fact, Tommy's mother was moved to urge passage of a law about sex offenders because the license plate was chartreuse. There's no question that they're still identifiable. What's the danger?
May I conclude your point?
Yes.
To add any symbols or to add any language would be to move this in the direction of private speech. However, it would be to take away the point that is government speech, to take away the point that we are putting sex offenders on notice. Now, it has been proven by our case that Tommy has been attracted to these symbols because he confused that with his mother's plate, who also had the school represented. So I believe to limit it, if I understand your question, would be to put forth the forum's purpose, secure the children of this state, and to secure the sovereignty this court and the Constitution has granted states in this country. Thank you, judges.
Thank you very much, Mr. Mercado. Mr. Mancino?
Good afternoon, Mr. Chief Justice, Your Honors. May it please the Court, my name is Joseph Mancino, and I represent Respondent, the State of Froessel, on this appeal. Respondent asked this Court to reaffirm the decision of the Court of Appeals for the 13th Circuit, holding that Froessel Traffic Law Section 2D was a lawful regulation of the state's specialty license plate program and not a violation of the 14th Amendment. The Froessel Traffic Law Section 2D, the respondent asserts, is a constitutional regulation for the following three reasons. FTL 2D is a reasonable restriction of the government's specialty license plate. There is a compelling state interest in ensuring that the economic interest of the state continues to remain in the community and being reinvested in the community. And the statute is equally applicable to all individuals.
Could I ask, the statute on its face says it places certain restrictions on groups that represent the interests of those who are not U.S. citizens. Does your argument depend on our interpreting, quote, not U.S. citizens to be not aliens? Or can we just put aliens in the statute where it says not U.S. citizens?
No, Your Honor. Respondent's argument circumvents around a plain meaning of the statute.
No, but can I just strike not U.S. citizens and put aliens in there?
No, Your Honor. Respondent asserts that the statute would be unconstitutional if it asserted explicitly aliens, yet the plain meaning reading of this legislation says that Section 2D prohibits a specialty plate from being issued to a group that represents the interests of those who are not U.S. citizens. The implication is placed, I apologize, Your Honor.
No, go ahead.
The implication is placed on said group, and said group could be 100 United States citizens, as His Honor noted earlier, who want to represent interests for Italian Americans abroad, or 100 non-citizens of the state of Froessel that want to represent that same interest. It would be equally applicable to both groups in this, under a plain meaning of the statute.
Representing people who are aliens.
No,
right?
Your Honor. No. The statute, what it does is it ensures that the funds raised pursuant to the specialty license plate program, which as per the statute gets split going back to the government through the Department of Motor Vehicles, and then back into the community through the conduits of the local community organizations.
So I still am unclear as to what is meant in simple English by the phrase, a group that represents the interests of those who are not U.S. citizens. What interests are we talking about?
The state of Froessel would like to ensure that the charities...
We're not asking about what it does. We're asking about what it says.
Yes, Your Honor.
What do those words mean?
Those words put the interests of the residents of the state of Froessel above all. Those interests continue to be the fundamental right that the...
No. I'm talking about the language of the statute. No specialty license plate shall be issued to a group that represents the interests of those who are not U.S. citizens. And my question is, what is meant by those words? And I'll focus first on interests. What kind of interests are we talking about here?
The interests implicated are the programs and types of initiatives that the state would like to go forward with their residents. Now, by interest of those who are not United States citizens, they continue to express the importance of the interests of the members and representatives of the class of the people of the state of Froessel.
But Mr. Mancino, if that's all it means, why do we need Section D? Isn't it already covered by the language of C2, where it says the funds have to stay within the community? It seems that your argument is that it doesn't mean anything more than what's already stated there. And that's not really a rational way for us to interpret the statute. If it's an additional section, it must mean something else.
Yes, Your Honor. Section C2 is the initial time in the statute. It's the first mention of the word charitable, so it goes to the interests that are being implicated. And then Section D it
doesn't only say
effectuates. I
charitable.
apologize.
It says that we will only issue license plates, that the funds that are made from the license plates must be used for the applicant's group charitable work in the community. So if your argument is that the people who are not U.S. citizens only refers to the same thing, that it has to be for people in the community, why would they need to say that at all?
Well, Your Honor, the in the community, what it does in effect when the state of Froessel enacted this statute, it shows the importance and it shows the value in continuing to ensure that there's a high quality of life within the community. Now, that notwithstanding, if there was a public park, for instance, that wanted to apply for a specialty license plate that contributes to the cause, benefits a park located in the state of Froessel, and it benefits the residents of the state of Froessel, and secondarily, or not even secondarily, I apologize, not secondarily, it may also spill over to benefiting those that are not residents, those that are not citizen residents of the state of Froessel. So it doesn't necessarily implicate that an avenue would be closed off, yet because the benefits could still be achieved through the purposes of the non-United States citizens in the state of Froessel.
Aren't non-U.S. citizens, by definition, aliens?
Yes, Your Honor, they would be aliens, and understood the jurisprudence of this high court has always been to afford additional protections for aliens.
Isn't this on its face a classification that discriminates on the basis of alienage?
No, Your Honor, it is not, because we go back to the fact that a group can implicate a group of citizens, a group of non-citizens. It goes to the function of what the funds go towards and what they represent.
But they're protecting the particular group that's being disadvantaged by this particular provision is the group that supports aliens. So the statute is, on its face, directed against groups that help aliens. Why isn't that clearly a distinction that hurts, distinguishes, classifies aliens?
Because a plain meaning reading of the statute continues to compel that this will not only affect aliens, that this would affect a group of citizens that wanted to provide foreign services for Darfur, for argument's sake. If they want to provide international aid, they would not be able to, despite their laudable goals. It does not go to the further ends of the community wanting its resources continuing to be reinvested within the state of Froessel.
Well, doesn't that just make this a viewpoint discriminatory statute?
No, Your Honor.
You think you could have a statute that excluded from this program people who were opposed to the war?
No, Your Honor.
You don't. So why isn't this? This is saying if you are a group that expresses a certain point of view or adheres to a point of view, namely a group that does things to advance the interests of non-U.S. citizens, you're excluded from this program. Why isn't that just flat-out viewpoint discrimination?
Your Honor, it's not flat-out viewpoint discrimination, and Respondent urges a rational basis review of the statute because of the overarching compelling...
No, but tell me why it's... I understand your doctrinal. Tell me why it's not discriminating on the basis of this group's express viewpoint. Namely, their viewpoint is we do things to advance the interests of non-U.S. citizens.
Because if this statute is taken to its logical end, it would be viewpoint neutral, given the fact that
but if a group worked against the interests of U.S. citizens, would you against the interests of non-U.S. citizens, would you agree they would not be excluded from the program?
I'm sorry, Your Honor, there were two double negatives there.
If the group worked against the interest of non-U.S. citizens, they're eligible under the program, aren't they? It's just people who work for the interests of non-U.S. citizens.
No, Your Honor, because in the example, they would have to be providing services to the state and residents of Froessel, and the other resources going back to the government directly.
Okay, I don't see that in Section D, but why don't you go ahead?
Okay, thank you, Your Honor. Respondent urges that we look at the plain meaning and we look at the legitimate state interest of this economic concern due to the importance of ensuring that government programs continue to exist. And we also look that the petitioner in this event has a high burden to prove that this has a discriminatory effect to petitioner Naveed Ali in the instant matter.
What do you what do you suggest is the appropriate standard of review that we should apply? Strict scrutiny, rational basis, somewhere in between?
Your Honor, respondent strongly urges that just as the Court of Appeals for the 13th Circuit held, a rational basis review of the statute, given the reasonableness behind the compelling government interest.
Counselor, if we were persuaded by your adversary that, as applied, the Commissioner made the assumption that Arabs are not U.S. citizens, would that be discriminatory?
No, Your Honor. If we look at the statute as prescribed, and you look at case law that this Court has forwarded, such as Palmer v. Thompson, where public pools were closed, which affected African-American children and white children, and despite the fact that disproportionately the minority children were affected, it was held to not be a violation of the 14th Amendment.
But isn't that different here? She's making an assumption and just denying the application based on the fact that it benefits Arabs who may indeed be U.S. citizens. Isn't the assumption that Arabs are not U.S. citizens a discriminatory assumption?
No, Your Honor, it's not, because in effect, if a non-U.S. citizen is applicable to participate in this program, a non-U.S. citizen can continue the work of a charitable organization within the state of Froessel, provided that they continue the work of the state of Froessel. And as an aside, given the fact the respondent concedes and finds Commissioner Cloverfield's statements reprehensible. These are not statements that we would not want.
Which statements are you referring to?
The statements regarding the specialty license plate and the quote-unquote reasons given for the license plate.
She had numerous reasons. Which ones are you referring to specifically?
Well, Your Honor, given the fact that the statements were made and that they are in the record, specifically what's important to note is the petitioner had 3 chances to continue to forward his application. But what happened was, under any of these circumstances, the petition should have failed under Section 2D. And Commissioner Cloverfield, despite the fact that respondent does not agree with the statements made, continued to give the application back to petitioner, let petitioner remedy it. The first initial one, there was a concern whether the group would cover the construction costs of the plate, the printing costs, which is important. The statute itself calls for 2,000. If you do not have 2,000 applicants, it could get subverted by a 500, provided that there is a viable backup information behind it. Yet this statute at any time could have failed, given the fact that it violated 2D.
I'm not. Why are we getting into the specific reasons that were given by Commissioner Cloverfield? Aren't we supposed to look at the statute on its face? Were there reasons? Were there factual findings that we can rely on by the district court?
Well, Your Honor, we would look at the plain meaning of the statute and the statute on its face, and the appellate court found that there would not be a disproportionate impact amongst the people who are seeking to have a specialty plate program. We'd also like to draw the court's attention to a legitimate interest, such as in LeClaire, which was a Fifth Circuit case which regulated those that were admitted to the bar. Non-immigrant aliens were not able to be admitted to the bar pursuant to the law that was being challenged, and the court in the Fifth Circuit found that it was a compelling interest because there was a rational distinction that could be made, and it was important to preserve the jurisprudence of the state and ensure that equal representation would occur.
Isn't that very different from the situation we have here?
No, Your Honor, because it still shows that there is a compelling interest at hand, and that is to ensure that the legal system is maintained with high quality. In the instant matter, it's to ensure that the state of Froessel continues to put forward its own mission and continues to provide services to the residents of the state of Froessel.
Yeah, but they could be non-citizen residents and still it would go back to the community. So why does it say it can't be for the interest of non-citizens? What's the compelling state interest there?
Well, non-citizens are still, as discussed, non-citizens are still benefiting from this program in the park example, how a greater community interest will have effects to residents of the state of Froessel and non-residents in the state of Froessel. So respondent urges that this court adopt a rational basis review of the statute.
If we decided that the appropriate basis for review was strict scrutiny, would you lose?
Well, Your Honor, this would be an issue of first impression for this court, asserting as an economic interest, as a compelling fundamental right. I do think it's important to note the context that we live in these days, given the state of our economy nationally and given the state of our state economies as well, states being on the verge of bankruptcy.
Is that your proffered government interest is solely an economic interest?
Well, I think this is I apologize.
No,
I
that's
think this is a primary government interest, is ensuring that the community is able to take care of and to provide services for the residents of the state of Froessel. And I think that is an overarching and compelling need for residents of this community and for the government to provide those services for its citizens.
But why
When has the state of Froessel not been verging on bankruptcy?
I apologize.
It was an inartful question.
Mr. Chief Justice, I see my time is up. May I conclude?
Briefly.
Thank you, Your Honor. Accordingly, we hope the court will hold a rational basis standard of review, given the very important interests of economics, and given the fact that this statute on its face is not facially discriminatory, and the fact that we believe that we should defer to the state legislature. Thank you.
Mr. Hagstrom, you may have your rebuttal.
Petitioner would like to waive rebuttal.
Right. We thank all four advocates at this juncture, and will be declaring a recess so that we may deliberate the matter. This tribunal has a record of being exceedingly prompt in deciding matters. Not having to write an opinion is a great advantage in expediting that process. So don't anybody go anywhere. We have marshals posted around. We'll take our recess. We will decide the matter, and we will return hopefully with dispatch.
Can I get everybody to take their seats? The judges are ready to render their decision.
Be seated. For those of you who are old hands at this, you know that upon our return, following deliberation, our purpose is twofold. first of all, we designate the winning advocate from the competition. And I emphasize that that decision by us is not one that turns upon the merits, the legal merits of the problem. We're not deciding this case as a court would. Certainly, each advocate's command of the legal issues as well as of the record that forms a part of the problem is fundamental to how he has actually performed. But we are rather making our determination based upon the performance of the advocate, the responsiveness, the ease with which the advocate has responded to questions and navigated his way through the various interruptions and so forth. And then after that, we will have some comments. I will ask each of my colleagues here to provide some insights into oral advocacy based upon our collective experiences with how advocates with whom we've worked, advocates who have appeared before us as judges, have performed, and what we think you may be able to derive from that that is of value. But let me first turn to that which I'm sure you are all more eager to hear than you are eager to hear us, and that is the announcement of the winning advocate. These decisions are always difficult ones, and this time was certainly no different. We know the degree of preparation to which all of you went, and we commend each of you for your command of the issues and for your respective performances as advocates here. But the panel has determined that Mr. Hagstrom is the winner of this competition. I would like at this time to call upon my colleagues to give you their observations, not only of today, but perhaps of greater import more generally, to the whole business of being an advocate and of how you can best serve that role in presenting your respective clients' positions to a court, whether it be a trial or district court or a court of appeals. And with that in mind, I'll first call upon a distinguished federal judge, Judge Rakoff, who sits to my right.
Well, first, with all due deference to our very distinguished Chief Judge, I want to say, go Yankees. I am very, very, very disappointed that the lawyers who appear before me every day aren't nearly as good as the four lawyers who appeared before me today. So I want to say up front that I thought all four of you were remarkably well prepared. Also, you kept your cool. This is not an easy thing to argue for 15 minutes before a so-called hot panel. None of you fainted, none of you collapsed, and more seriously, you were always able to give articulate responses, and I think that is one of the hallmarks of good advocacy. And it only comes from preparation, which is clearly what you had. I do think there were a few occasions when the responses were not to the answers put, and that is a mistake. It didn't happen very often, and I'm only emphasizing it because when it does happen, I think the way a judge looks at it is that he or she says, I guess he doesn't really have an answer to that question. Oftentimes, it may be that you don't understand the question, and I thought something that was good was several times various of the speakers said, would you please repeat the question? Because often the questions are unclear and need to be clarified before you can answer them. But there were a few occasions when the answers really were not directly responsive to the questions, and I just want to emphasize that is something to be avoided because of the inference that most judges will draw, which is that you don't have an answer to that question. A much more trivial point is whether you should come across at the outset as canned. I'm sorry to use that word. Most of you stood up and said, in effect, I've got 3 points, blah, blah, blah. You never got, of course, beyond point 1 or 2 at most. And I think that's often what's taught in many advocacy courses. And it's not without value. I think, and there may be different views here among the panel, I think to many judges it comes across, I'm about to hear a canned speech, rather than someone who wants to have a dialogue with the court. And what you should be aiming for is a dialogue with the court. You want to, it's always going to be easy when the court's on your side, but when there's a judge on the panel who's against you, you want to, or starts out against you, you want to engage that judge in a dialogue and see if you can persuade him that there's some area of commonality that will allow him to rule for you. And that means, I think, from the very outset, coming across in a little less pre-planned, a little less formalistic way. You might start out by simply saying, I want to address what I think may be the more controversial issue in this case, or I want to start by clarifying some of the things that are not in dispute. Or it'll vary tremendously with the case, but I think the point is not to come across as too pre-planned, because you won't be able to persuade a judge who's read your brief and decided against you on the basis of the brief if you start out with what is essentially a précis of your brief. So those are my comments.
Thank you, Judge Rakoff. And just for clarification, I like the Yankees. You may have noted that I was careful to mention only the Steelers, and I yield to no one with respect to that team. The Pirates, however, are just finishing their 17th consecutive losing season. Judge Codman.
The Giants, of course, are playing today. So, go Giants. I thought that, with all respect, as they say, I thought that all of you were very good. It is hard to underestimate the difficulty of getting up, particularly in law school, and answering questions from a panel of judges, and you all did it very well. You kept it going. We were discussing at the break examples of other times when people have not done nearly as well. You all did a remarkably good job of attempting to engage with us, listening to the questions, answering the questions, maintaining your composure, and all of that you should be complimented for. With respect to the issues of style that Judge Judge Rakoff commented on. Judge Gerfine years ago wrote an article about who was a very distinguished member of the Southern District of New York and then the Second Circuit on oral advocacy, modern style. And the difference between oral advocacy today and what was the time in the days of Lincoln Douglas is that indeed it is a process of engaging the court, listening to the questions, picking up on the questions, understanding what it is that's behind the questions, and attempting to persuade the judges of your point of view, to know your arguments so well that what you really want to say you can include in the answers to the questions. So that brings me to the issue of the 3 points. I'm not a fan of the beginning with the 3 points. I think the most important thing about an argument is to ask what the most important issue or 2 issues are, and to get those out in an effective way at the beginning of the argument. Many years ago, I listened to an argument in the Supreme Court by Charles Allen Wright, a great law professor and advocate. He was arguing the San Antonio School District against Rodriguez, which was about the Equal Protection Clause for funding of school districts. And he was arguing on behalf of the San Antonio School District, and he began the argument by saying the issue in this case is whether more money necessarily means better schools. We say it ain't necessarily so. And the justices looked at each other and said, yeah, I went to a poor school. It was a good school. And he was successful. One advantage to beginning with 3 points is there may be one of the judges who eventually, you will often be stopped by questions after you begin to get, you get out your first point, and then the judges begin to ask questions. You never get to your second or third point. Sometimes one or more members of the panel may say, I think you had a second or third point. Could you tell us what it is? But if someone doesn't do that, you've sort of left people hanging. The bottom line is, arguments are very, very different, and you've got to ask what's the best way of presenting this particular argument. I would also have a line or 2 to end the argument with your most important point. What is it that you're asking the court to do? Even if it's nothing other than, therefore, we urge the court to affirm the decision below, or therefore, we urge that the court reverse, so that it's just not left completely hanging.
I like Judge Kittle's point about the 3 points. I had a somewhat different experience, and it was to hear before a very seasoned district judge in the Eastern District of Pennsylvania many years ago, who responded to a gimmicky use of the 3 points. Your Honor, our argument can be condensed into 3 points. Appellant's position is not represented by the record, number 1. Appellant's position is not represented in the record, number 2. Appellant's position is not represented in the record, number 3. And this district judge, whose name I won't mention, leaned forward and said, well, counsel, I get your points 1 and 2, but I'm having a little difficulty with the 3rd. Judge, Professor Abraham.
Thank you, Judge. I first want to thank all of the judges on the final round bench for giving up a Sunday and offering us all of their wisdom. I think they were great. And second, I want to really applaud all 4 advocates, because I thought you all showed incredible poise, stamina, and preparation. You were clearly very prepared. You knew the record very well. You knew the case law incredibly well, and I'm really looking forward to working with all of you and the whole new team this coming year. As to specific comments, first of all, with all this talk about the Giants and the Yankees and the Steelers, I just want to say I hope you appreciate that there's at least one woman on this bench. And I think I know how Justice Ginsburg must have felt last year and how happy she is. Okay. I agree with a lot of the points made. I think that it's one of the hardest things as a new advocate is to prepare, and then tear it up and throw it away and really respond to the questions. Because all of your preparation is great, and of course if you get no questions, you're going to have to stand there and speak. But the most important thing and what you should welcome are the questions from the court, not dread. Because when you get those questions, that's your opportunity to really persuade the court about things that they're really still thinking about. And that's your window into what's important to them. And it's not about what's important to you. It's about what the court wants to talk about. And as soon as you hear these are the things they're struggling with or thinking about, then you should light up and say, yes, this is what I want to talk about too. And it may be hard because you have to think on your feet, and you're all doing that. But what you really need to do is actually specifically answer the question. And sometimes it feels more comfortable to respond by citing a case, but that's not what your first answer should be. When you're asked a question, yes or no, or not really because, and then you can cite a case for comparison or support, but don't just jump to the case without answering the question. It's really important to answer it first. You did that most of the time, but once in a while there were some questions that never got answered, and you might have seen a little frustration up here on the bench. Other than that, I just want to remind everybody that conceding is sometimes smart and good, and if you're conceding a small point and you can still win on your large argument, you gain a lot of credibility by doing that. So don't be afraid to concede something that shows that you're reasonable, that gives you credibility, that just doesn't take away from your final argument. You're trying to be persuasive, but you have to be realistic, and you lose all credibility by not conceding anything. And then a small point, which we can talk more about throughout the year, is I understand that everybody's trying to avoid I when you're making your arguments. You don't want to say I think and I feel, so everybody's saying petitioner's argument is and respondent's argument is, but I would urge you to do away with that and just say, no, this is right because, or in this situation, this is the way the court should rule because when you say petitioner's argument is or respondent's argument is, you tend to sound like you're distancing yourself from your client and you don't quite believe it as wholeheartedly, or at least that's my response to it. And it adds a lot of words and jargon, which I think clarity and being concise actually is more important, and showing that you believe in your argument by just saying what it is without all of the introductory language can be really helpful. But I think everybody did a great job, and I'm really looking forward to seeing more of it.
It's difficult to stand there and be pummeled by a panel with questions and interrupted. A good friend of mine with whom I worked many years ago on a major criminal investigation was appearing before a court not too many years ago before the Third Circuit. I was not on the panel, but my chief judge, whom I know Judge Codal knows, and I'm sure Judge Rakoff knows as well, Chief Judge Tony Sirica, was presiding with two colleagues, and Tony's a very quiet guy, so I'm sure he was maintaining his usual demeanor. But the other two members of the panel were pummeling my friends with question after question. And his position was not the strongest. He knew this. And at one point, out of perhaps frustration, he looked up to Judge Sirica and said, "Judge, could I be doing any worse here?" This is not an approach that I advocate for any of you, but it is an indication of the frustration level that we can reach sometimes as advocates. Judge, Mr. Dunn, your comments.
Well, since everyone's made a sports reference, I just have to say, and this will be a little bit of a quiz, not a quiz. The last time I appeared before Judge Rakoff, the first thing he said was, I am a Yankees fan, my law clerk is a Red Sox fan, and my courtroom deputy is a Mets fan. And he was not being sociable, so you can try to figure that out. I come at this from the other side of the bench.
That was because I wasn't about to recuse myself in a case involving the Yankees. That's it.
You went and gave it away too quickly. I'm on the other side of the bench. You're getting terrific advice from people who listen to arguments all the time. I supervise young lawyers who do what you were doing today, and who come with all the nerves and the lack of depth of knowledge and the lack of experience, and they're trying to develop into lawyers. So what I really bring to this is a lot of empathy for the position you were in, and I thought, for the most part, you did very well. I mean, I think the big stumbling block was responding to questions, and everyone has said that. And it's difficult when you have a speech you want to give, and oftentimes people think they should be giving a speech at a lectern, or you're nervous, and there's every reason for all of you to be nervous, to respond to questions, particularly if they're difficult. And you just, at some level, you got to take a deep breath, you got to make sure you hear what the question is, and you need to answer it. And waiting 3 or 4 or 5 seconds to think about it is fine. You do not need to blurt out an answer. And oftentimes, you're going to get asked questions that you're not going to have anticipated. And sometimes you won't even necessarily have a good answer. And there's nothing wrong with saying sometimes, that's a good question. I actually don't know the answer to that, but I will do something to get you an answer to that. The only thing I want to mention, which has not been discussed, is the issue about rebuttal. And these have been general comments. You're the one person, of course, who had a rebuttal opportunity. And we were talking in the break about, your decision not to take advantage of that, and I'm not going to put you on the spot by asking you. But, in terms of rebuttal, and this relates a little bit to the question answering, when you are the appellant or the petitioner, you have the disadvantage of being the first person up. And you have a lot of stuff thrown at you that you just have to deal with. The respondents have a huge advantage in the sense that they get to see what the panel is doing, what they're interested in. And as respondents, you always want to think about and make sure you understand what you learned when the other side was up, which gives you an enormous amount of information. And you need to be able to get up and incorporate that into what you heard and then what you say. Okay. Conversely, in the rebuttal, we gave these guys a very difficult time. There was a fair amount of stuff that got thrown at them. And I think that most lawyers would say in a case where it's a close case, it's a difficult case, and you have a panel or a judge who you hear giving the other side a lot of trouble, there probably are things that can and should be said in rebuttal to pick up on what you have heard. So one of the tricks here, and it's a trick throughout in all presentations, is you need to learn as you go, you need to hear what is being said, and you need to be flexible enough to be able to change what you are saying in light of what you were hearing from the judge. So as Judge Kodal said, you need to come in ideally that you know everything so well that you don't need to have a sequence, you don't need to have a speech. You can get asked 25 different things, you will have an answer to those 25 different things, and you will understand how they relate to other things, and so you will have a fluid argument. And that's a very difficult thing to accomplish, but you are up there engaging with the court. Okay? It is not an opportunity for you to talk at the court. It's an opportunity for you to deal with the judge who's going to decide the case. And you have got to deal with him or her in a way that will get him or her to be on your side. And that requires the interaction. So what I would say when you come out of this, the single most important lesson is you need to be able to tailor what you were doing so you were actually engaging with the judge, answering the judge's questions, and responding with what the judge does to the other side, because that is very telling.
You have, in a short period of time, heard and received a profound amount of very sound and seasoned advice from judges and lawyers, which I hope all of you will take to heart. The advantage of coming last is I don't really have to add anything, and you don't have to listen. I I'm hearkening back to earlier in the afternoon before we actually convened, and we were talking, and Professor Abraham said something in the course of our conversation, which I think really said what argument ought to be. Probably most of the time isn't, but ought to be. And what she said is, this is supposed to be a conversation, and that is what it's supposed to be. Gosh, it is damn hard to get to the point through experience and the preparation on the case and the tensions that just naturally flow from being an advocate in a case. You can turn it into that, but boy, that's what the best advocates I have seen have made it. They've made it that way. The judges really have only contributed to it. It comes from an ease that you can only develop with experience and a comfort level that's pretty hard to achieve. But with persistence and the comfort that comes from considerable preparation, you can get there. You can actually stand at that podium and have a conversation with the court. Now, I grant you it's not a bilateral conversation unless you're appearing before a trial judge or a district judge, and I think there are probably advantages to that. But remember always, I shouldn't say always, we're sitting here in the Second Circuit where there's a tradition of giving oral argument to virtually everything, but that's not the case in most courts across the land. And so keep in mind that if you've been given oral argument, and on my court, the Third Circuit, oral argument is granted in maybe 1/4 of the merits cases that come to us. If we grant oral argument, it's because we have questions. It's because we want to hear from you. And as Professor Abraham said, we want to hear what we want to hear. We don't want to hear your pre-canned speech. We want to hear what we need to hear. Answers to the reasons why we've listed the case for oral argument. And so when you're asked questions, answer the questions. Don't tell us what you want to say because we want to hear what we want to hear. And we may attach an inference to your non-responsiveness, as Judge Rakoff has suggested. An adverse inference. All of you have acquitted yourselves very well today. This is a great program. I'd be remiss if I didn't thank everyone for the opportunity to participate again. I'm a recidivist. This is 4 years in a row for me here, and I commend all of the organizers. The problem was extremely well written, an extraordinary problem, really, and all of the people connected with the Froessel program treat those of us who are visiting and those of us who are judging extremely well. And Professor Abraham's become a friend, and she does just a great job with all of you as well. So I thank you all, and I know I echo the thanks from the other members of this panel. So with that said, I believe some of us need to leave. Some of us are going to be able to stick around. I know that there are awards to be presented. I think that there's a small social event and perhaps even adult beverages being served there in a short while, so I don't want to stand in the way of food or adult beverages. We will adjourn.
All right, you guys, I know you all want to know who won all the awards, so just stick around for a second and we're going to announce the awards. right, so here we go. We're going to start off the awards with announcing who had the best petitioner brief. And the team that had the best petitioner brief consisted of Benjamin Roth and Andrew Blancato. So you guys come on up here.
Next is the award for Best Respondent Brief, and that actually goes to a single competitor, Olha Koliznik.
All right, the next award is for Best Team. And the best team was Allison Quine and Cambridge Peters.
Our next award is for the Best Preliminary Round Oralist, and that goes to Darren Shields.
All right, so the next awards we have are the Morris Orland Awards, and these awards, there are 6 of them, are for both oral and written excellence. So the first one goes to Benjamin Roth. So we're going to accept that as and it will be accepted on his behalf by his partner.
The second one goes to Chris Arco.
The third award goes to Joseph Mancino.
The next one goes to Kai Livramento.
The fifth award goes to Paul Duffy.
The last one goes to Saren Chi.
All right, so at this point we're going to announce our remaining members, and the first one is Alana Slowinski. Everyone whose name we call at this point, Alana, you can just come gather up here. We're going to gather our whole new association up here for a photo.
The next one is Alex Leifson.
Benjamin Roth. Benjamin Jacobson, sorry. Benjamin Jacobson.
Dina Cremaldi.
Edmund Plaschek.
Frank Mazzaferro.
John Haig.
Joseph Welsh.
Justin Lerner.
Kyle Kunst.
Leroy Austin D'Souza.
Matthew Dubroff.
Nicole Siolko.
Rashin Patel.
Robert Povtak.
Sharon Carroll.
Stephen Mizrahi.
William Dax.
All right, so that completes our association. If you have already been called for an award or you've already been up here for some other reason, come on up so we can take a photograph of our new members. And old members, please stick around for our photo. Thanks, everybody.